overlap. And so the only suggestion I can make is go for that optional 2-year license for $20 for the altered and $35 for unaltered for the 2-year license.
Okay, I'm going to add that to the resolution so that it will be clear. Okay, so do we have a motion to accept?
Second?
Second.
Gelfarb?
Aye.
Mendocino?
Aye.
Nyworth?
Aye.
Villanova?
Yes.
Carter?
Yes,
As amended, right?
Yes.
as amended. And this is actually quite timely. I was actually at the lunch for the town supervisors yesterday, and there was a presentation from a gentleman from the county who's working with pet rescue and basically trying to, provide for pets in an emergency situation, so first responders. It's actually kind of interesting. Of course, it's so important then to make sure that all the dogs are properly licensed and all that, so it was good. Thank you. Town Clerk Vespia. Okay, Mr. Markowitz, are you going to make your presentation now? Yes. Mr. Markowitz and Mr. Arcaro? Greg, did that table ever get into it?
Yes, not in there. Anyway.
Thanks. Okay, this was not, okay. Okay. Well, Mr. Noto, I know you're going to enjoy this presentation in particular. Usually at most of the town meetings, I'll talk about the problems of certiorari. And so I asked Mr. Markowitz to prepare a report over this issue.
Thank you, Mr. Corbett.
Thank you.
This is the first report prepared by the town of Rye since I've been assessor. I knew this. Okay, I'm sorry.
Yeah, the other one.
You might just put the blue one.
Yeah.
Blue ones.
It's the third switch, I think. Right there, that's it. Right there. How's that?
It's on me.
Okay, now that everybody can see, this is the first time the town of Rye has prepared this kind of report. And what we attempted to do in this report is deal with some basics. Firstly, we tried to quantify assessment complaints made to the Board of Assessment Review. How many there are, what is their complaint? The second part of this presentation is a review of certiorari cases, which are those court cases that are pending in the system for commercial properties. And then following this train of thought, we looked at what are the potential tax implications of all these certiorari complaints, and then tried to end with certain recommendations to improve both the court system, the results for the town, and to put the town on what I'll describe as a more equal footing with those entities complaining and filing court cases against the town. If we go to the next slide, the first slide is just simply a bar graph of the complaints made to the Board of Assessment Review by commercial properties, which is the lighter shaded bar, and it's done by year. And then the red bar represents the total cert claims, the total number of certiorari filings by year. And as you can see,
This is important. Sorry if I could just, Mr. Markowitz. So basically, what you see is effectively 75% of the commercial properties that file a certiorari claim end up going, a bar complaint, end up going to court. So this is the number of complaints that go to the Board of Assessment Review, and this is the number of actions that ultimately end up in court. Sorry.
it's okay. Can we go to the next slide,
I have a
please?
question on that.
Okay.
please.
Can you go back?
Yep.
My question is, why is that percentage so high?
We get, just hold that question if you could.
Oh, you answer it later? Great.
Okay. The next slide, please. The next slide represents, by year again, the number of claims against town assessment by both the residential property class and the commercial property class. The green being the residential property class by year, and the red being the commercial property class by year. And what we attempted to do is show the claims made by the homeowners, how much in assessment they disputed, and what they told us their values were for both the residential class and the commercial class. The obvious conclusion from the graph is the fact that the residential class makes much more reasonable requests and is a lot closer to, our assessments than the commercial class, who simply, makes requests at 10 or 20% of their assessment.
Okay, so now, just to make sure everybody understands this. So basically, a resident will come in and say, look, you have my home valued at $500,000, and I think it's worth $400,000. So you see, there's a little difference between the two. Whereas, as a first answer to your question, most of the commercial property owners that come in on day one are bound and determined to go to court. It's a legal tactic rather than an honest exchange of views on the value of the properties. So you can see, here's the value we have these properties assessed at. The commercials, they're coming in at 20% of value. They're saying my $1 million home is only worth $200,000. That's the equivalent. Again, $900 million in value, they're saying 200. Again, 20% of value. So they're effectively, it's a legal tactic, or if we're even a little bit more skeptical, they're gaming the system. And you can see that's a very different approach. No homeowner would come in and say my $1 million home is worth $200,000. They'd be, they'd be booted out of the community. Sorry.
Next slide. Go ahead. I'm sorry.
Another question on this particular slide. You have here the assessed value of the properties of residential versus commercial. What about the number of properties?
We'll get to that. We'll answer all your questions. Maybe Councilman York.
Just to put it in perspective, I'll use 2010 numbers.
Now we'll get to bits. Let's just get.
Okay,
we'll
let's keep going. Next slide, please. The next slide is, again, a bar graph by year of the town's assessment that complaints were made against and the claims made in the court system as to what their value is. So, for example, if we had an assessment of $1 million on a particular commercial property, the typical claim would be $150,000 to $200,000 is what the complaint is telling us the value.
It's the same slide replicated here without the residentials. And you see the track record back to 2004.
Next slide, please. The next slide actually plots the complaints by class, by residential property class and commercial property class to the Board of Assessment review, and then compares that to the number of people who go on to file court challenges. And it's done by the residential property and the commercial property. If you take, for example, 2010, the blue bar represents the residential houses, and what it says is that 40% of those homeowners who filed with the Board of Assessment Review went on to file what's known as a SCAR, Small Claims Assessment Review, with the court system.
Sorry, but 2010 is an unusual year. Basically, you can see, because the big change in the property values, you can see basically the residentials, for 100% of the complaints, 20% on average, 20% of the residential complaints ultimately end up in court.
Yes.
And you can see 80% of the commercial complaints end up in court. Again, when the commercial comes in, they're going to court. No matter what. Remember, the whole reason we're talking about this is because we've done the reval, And ultimately, the goal is, or the reval was to reduce the certiorari filings. And that hasn't been the fact. Mitch, let's just state. Sorry, go ahead.
Just, I guess, a small point raised by Councilman Gelfarb is that included within the certiorari filings is a very, very small number, probably measured by my two hands, of residential properties who file asking for reductions greater than 25%.
Okay.
Just to clarify that.
Question on this one, hopefully you're not going to answer it later.
Okay.
So, if I read this correctly, you're saying that 80% of the commercial entities filing certs ultimately went to court. Is that correct?
I would
Almost 80% of the commercial.
80% of the commercial entities filing at the Board of Assessment Review go on to file with the court
Because
system.
the point we're trying to make here is effectively the commercial properties are making the Board of Assessment Review a non-entity. They're making the Board of Assessment Review nonsense.
I don't see that here.
What?
So my question is, are they going through the Board of Assessment Review with the specific purpose of marching through the steps to go to court?
Yes,
Okay.
yes, because 90% of the complaints are 10, 25% of value.
Okay.
Right.
Any other questions?
So the board has no...
That's the whole point. It's a nonsense. They've made it a non-entity. They made it a nonsense.
Okay, if we move on to the next slide, we're going to make a few observations about...
And here are the numbers exactly. So basically, this is the average value. Sorry, Mitch, but so basically, the certiorari complaints filed in 2004 were for 800. Bob, this is your answer to your question.
Yep.
So $819 million in value was complained. It was our assessed value for the complaints that came in that year.
Right.
And basically, they came in and said it was only 22% of value. And across the board. In 2009, it even got worse. They're at 16%. So again, what we've had situations where basically the property owners don't even know that they're complaining because the lawyers are doing it on their behalf. We've had certain properties, we have 3 lawyers filing the complaint on the behalf of the property owner.
And it's just to point out the absurdity of the situation. Part of the bar process, there have been times where we've had to send requests to owners of property as to who their representative is. Okay? Because we can't tell from the filings. We send out a letter that says we received 2 filings or 3 filings on your property. Please designate who is your representative. We have a checkbox next to the 2 names, and they check it and send it back, sign it and send it back.
Okay, next slide.
Okay, next slide.
Well, okay.
Go ahead.
I mean,
Bob, but can we get through the presentation, then we'll discuss.
Okay. This is sort of our observations based upon what we've charted and what we've looked at, that since 2004, 22% of the residential properties who file with the Board of Assessment Review go on to the court system to file what's known as a SCAR, Small Claims Assessment Review. At the same time, using the same years, about 75% of the commercial property owners who file with the Board of Assessment Review go on to court, better known as the certiorari process. The second point that we'll be discussing in detail a little bit later is that the commercial property owners have 4 years after initiating a cert to file what's called a note of issue, and town council will address that, I'm sure, indicating that the owners of the property or their representatives are ready to go to trial. The court, once they get this note of issue, then starts to set the process in motion by which there are hearings, there are meetings,
So
discussions.
Town Attorney Noto prepared a memo for the board for tonight's meeting. But this is the most important point. So the town, and correct me if I'm wrong, Town Attorney Noto, has zero capacity to bring these to basically force a court hearing.
Sure.
We sit there for 4 years with a knife over our heads, waiting for the property owner to bring the property to, and then I think you mentioned here, but then there's a 9% penalty interest. So we wait 4 years. They've come in at 10% of value. Then they go, oh, it's not 10% of value, it's 80% of value. Let's split the difference. We go to court. If we go to court and lose, it's a 9% penalty interest over the course of 4 years.